Okay, if this is clear, we can proceed to inquiries and country visits. Country visits and inquiries are mainly implemented in cases of gross violation of human rights. They are in place to prevent or to redress a massive and gross violation of human rights. It's consent-based mechanism, and it also have a protectional role for human rights. So most of the supervisory mechanisms and most of the treaty bodies involve inquiries, but others may entail initiatives which are aimed at preventing violations or promoting compliance with specific human rights issues. They play a rather, passive role as they generally cannot initiate proceedings by themselves, and they are largely dependent on information submitted by governments or individual plaintiffs or petitioners. So in all the three mechanisms that we have seen earlier, the treaty body will just rely on information from government or from individual complainants. But however, when we see country visits and inquiries, it is the treaty body itself that will see the human rights situation in the country. It's not just relying on a report or a finding or a complaint by third parties, individuals or governments, depending on the case. ስለዚህ for country visits and inquiries, it's just the treaty body itself which is going to inquire into a human rights violation in that state, or it's the representatives of the treaty body which will visit the country. So this makes it somehow different from the other three mechanisms which we have been seeing. And there are 6 treaty bodies which allow for inquiries. These are the Committee Against Torture, allows country visits and inquiries, the Committee on the Elimination of Discrimination Against Women, also allows this procedure, and then in the third place, the Committee on the Rights of Persons with Disabilities have this procedure. On the fourth place, the Committee on Enforced Disappearance and the Committee on Economic, Social and Cultural Rights, and the Committee on the Rights of the Child have these procedures. These 6 treaty bodies have this procedure of country visit and inquiries, and they may initiate inquiries if they receive reliable information containing well-founded indications of serious and grave human rights violations of the conventions ratified by a state party. So when we see which states may be subject to inquiries, with the exception of the Committee on Enforced Disappearance, for which a state parties automatically accept the committee's competence when they ratify the convention, inquiries can only be undertaken by the other committees only with respect to state parties that have separately and specifically recognize the competence of the treaty bodies. It is only for the committee or the treaty body on enforced disappearance that the state will automatically be accepting the committee's competence to make inquiries. But for all the other conventions, a state need to explicitly recognize the competence of the committee to do inquiries. So states at the time of their signature, ratification or accession need to make an express declaration for the treaties except, as I said, the Enforced Disappearance Treaty. For instance, if we look at the Convention Against Torture, a state needs to make this declaration accepting its mandate of inquiry under Article 28. And also, if we see the CEDAW, state parties to the optional protocol may make a declaration accepting inquiries under Article 10 of the CEDAW. So using the respective articles on country visits and inquiries, states need to make an express declaration. We have the Convention on the Rights of Persons with Disabilities, and a state need to make this similar declaration under Article 8 so that the treaty body of the Convention on the Rights of Persons with Disabilities can make country visits and inquiries. And any state which opts out the procedure in this way may later decide to accept it. So it's just something you can change. You can opt out the procedure and then you can also come back again. And the optional protocol also for the International Convention on Socioeconomic Rights also allows inquiries and country visits if the treaty body receives reliable information on a systemic violation, a grave violation of human rights by a state party. Yeah, so states, as I said, can opt out this. It's something consensual, but for those who have opted in, the treaty bodies will make inquiries on the human rights situation of the country, and when we look into various human rights violations or a specific human rights violation depending on the case, and will take measures and will recommend the state to succeed the violations taking place. So when we see how exactly the inquiry procedure is played out in practice, the procedure may be initiated once the committee receives reliable information indicating that the right content in the treaties are being systematically violated by a state party. So, for instance, for inquiries under the Convention Against Torture, the information should contain well-founded indications that torture is being systematically practiced in the territory of the state party. For inquiries, for instance, under the Convention on the Elimination of All Forms of Discrimination Against Women, the information should indicate a grave or systematic violation of the rights of women as it is set forth in the CEDAW. So then the committee will first invite the state party to cooperate in the examination of the information submitted, and it will hear what the state has to say, and it will ask and invite the state to cooperate so that the committee or the treaty body may be able to examine the information. And then the committee may, on the basis of the state party's observation and other relevant information available to it, it will decide to designate one or maybe more than one of its members to make a confidential inquiry and report back to the committee. So the procedure under the Convention on the Elimination of All Forms of Discrimination Against Women, the International Convention on the Protection of All Persons from Enforced Disappearance, and the Disabilities Convention. These three conventions specifically authorize a visit to the territory of the state concerned if warranted and if the state consents to this. Visits are also envisaged under the Convention Against Torture. So with the consent of the state, the committee will make the visits and inquiries. So the findings of the members of the committee will be examined, and then it will be transmitted to the state party together with any other appropriate comments, suggestions, or recommendations. The procedures under the Convention of Elimination of All Forms of Discrimination Against Women and the Convention on the Disability Rights set a 6-month deadline for the state party to respond. So once the committee makes the comments, suggestions, and recommendations, the state will have a 6 months period to respond with its own observations on the committee's finding and comments and recommendations, and then it will inform the committee of the measures that it has taken in response to the inquiry, if the committee, of course, invites the state to do so. And then after that, the committee may decide in consultation with that specific state party to include a summary account of the results of the proceedings, and it will include that in its annual report. And if the state party agrees, the full inquiry and the state's party's report and response may also be made public. So the cooperation of state parties is very important in this whole procedure. Throughout this stage, the states need to cooperate with the treaty body. So the very fact that a treaty body starts to inquire into a state's human rights situation will usually warn states, and states will, somehow cooperate with the treaty body because they don't want to tarnish their good name. But yet again, some states may not be willing to cooperate with the treaty body, so you need to take that this whole process is consensual. But usually states, will find it difficult to say no to the treaty body's request for inquiry, because usually the treaty bodies will start this process after receiving a very reliable information that there is a human rights violation in the state concerned, and the state would, in a way, want to use this procedure so that its point of views can also be heard. So when we see country visits, they work similarly or hand in hand to inquiries. And for instance, we can see that the optional protocol on the Convention Against Torture also provides for a practical means to assist state parties in meeting their obligations to prevent and combat torture and other forms of ill treatment, and also it strives to establish a global system of regular visits to all places where persons are, or maybe deprived of their liberty. So in the same way as inquiries, country visits also work in various treaties, in the 6 treaties that we have been seeing. So we have seen the optional protocol of CAT as an example. The other treaties also have these mechanisms, but the Convention Against Torture explicitly provides for this. For instance, the subcommittee on the prevention of torture empowers to conduct preventive visits to detention facilities. So the very right incorporated within the Convention Against Torture implies the need for a country visit detention facilities. Prisons need to be visited by treaty bodies if there is reliable information that there are human rights violations within those facilities leading to torture. Yeah, so this is how inquiries and country visits work. The 6 treaties where country visits and inquiries are provided for are the Convention Against Torture, the Convention on the Elimination of Discrimination Against Women, the Disabilities Convention, the Enforced Disappearance Convention, and the Child Rights Convention, and finally we have the Convention on Economic, Social, and Cultural Rights. So these conventions allow country visits and inquiries. And this whole process is consensual. So I think this is clear. If there are no questions, we can proceed to seeing into each of the 9 major international treaties and how the treaty-based mechanism works and which procedures are used in each of the 9 international treaties. But before that, if there are questions on inquiries and country visits, if something is not clear, we can discuss on that. Okay, okay, it's clear? Okay. Yeah, so this whole inquiries and country visits is a mechanism where the treaty body will send its members to the specific jurisdiction, to the specific country's territory, and those members from the treaty body will inquire into the human rights practice of that specific state. So the government is only asked to comment on the findings of the members of the treaty bodies. So those members that are sent to the state will look into the human rights situation, will see how the government is implementing human rights, and if there are violations, if there are, systematic violations of human rights. If the government is not respecting on human rights, they will report this back to the treaty body. And once this is reported to the treaty body, the members of the treaty body will ask the government to comment on the findings. ስለዚህ ገቨርንመንት ራሱ ላይ ሳይሆን ሪፖርት የሚያደርገው ኦልሬዲ የትሪቲው ቦዲ የወከሏቸው ሰዎች ሄደው ቦታው ላይ መሬት ላይ ሄደው ሂውመን ራይት ሁኔታውን አጥንተው መልሰው ለትሪቲ ቦዲው ሪፖርት ያደርጋሉ። ከዛ the treaty body will see that report and then will transmit that report to the government, and the government will have a say on the report, will comment on that report. So it's just commenting on the findings of the members of the treaty body. It's not the government itself that's going to inquire and that's going to visit back its own country. It's just to give the treaty body a full picture of the situation. Its members have gone to the ground. They have seen how human rights are being respected or not. And then the government will be given a chance to be heard, not to inquire its own human rights practice. I hope that this is clear now, Kia. Okay. that forces countries to have periodical visitations. Like it's not something mandatory. It's not mandatory, but it's based on consent. So a state can opt out inquiries and country visits procedures, but it can also come back again and allow inquiries. So it's all in all based on consent. So there is no, something mandatory that will force a state to accept inquiries and country visits. It's all based on consent. So are there any questions? Okay, yeah, there. Yeah, usually reliable information comes from NGOs working on human rights. It may be international NGOs that have a branch in that specific country, Human Rights Watch, Amnesty International. So there are NGOs working on specific human rights issues, and those NGOs can uh, give the treaty body a reliable information. Also, besides NGOs, we have national human rights commissions, national human rights institutions. You call them commissions, institutions, depending on the country. So those human rights institutions have also matched information on the human rights situation of the country. So those are also eligible to give information to the treaty body. And your second question was on whether. Can you remind me that? What was your second question? Yeah, yeah. Can they stay? Yeah. Um, Usually, when it's an organization, obviously they would be mentioned because when they have a trend of communication, there is no need to stay anonymous because their aim is to protect human rights and expose human rights violation by states, so they can stay anonymous. Their identity will only be revealed to the specific treaty body. The treaty body will hold their identity confidential to itself. It's not going to transmit it to states. So being anonymous is not possible. Because the treaty body needs to verify that the information is reliable, and one way of verifying the reliability of the information is knowing from who they are getting that information. So anonymity is something you would want for the sake of your security. But in the case of the treaty bodies, they don't transmit the names of those individuals or those human rights organizations to the government. So because they're not reporting back to the government, there would not be this issue of anonymity, or there won't be a need for anonymity. I hope this answered your question, Iyad. All right. Any other question? Are the three human rights protection mechanisms within the treaty-based mechanism clear to you all? Any questions? Okay. Okay, so because this is an online class, I just wanted to make sure that things are clear and that we are going together on the same page. Okay, if that's the case, we can proceed to seeing each one of the 9 treaty bodies and how exactly the human rights protection mechanism is implemented in the treaty-based mechanism. So each of the committees or the treaty bodies are composed of independent experts. These experts are of a recognized competence in human rights, and they are nominated or elected for a fixed renewable terms of 4 years by state parties. But even though they are nominated and elected by state parties, they don't represent the state parties while doing their jobs within the treaty bodies. So they are working in the treaty bodies only on their own personal capacity, and they are not working for their governments. They are not there representing their specific states. They work on their personal capacity as human rights experts. And they're not there to advocate for the interests of their own governments. They are neutral of their governments, but they are nominated and elected by state parties. So the treaty bodies generally meet at the United Nations office at Geneva, but the Human Rights Committee and the Committee on the Elimination of Discrimination Against Women, the CEDAW treaty body, usually hold one of their sessions in New York every year. So as I said, most of them meet at the UN office in Geneva, but the Human Rights Committee and the treaty body of the CEDAW meet in New York every year. So all of the committee works or the treaty body works is supported by the OHCHR, the High Commissioner for Human Rights, with its experienced and well-qualified secretariat. So the secretariat supports the treaty bodies while they undertake their day-to-day work within the treaty bodies. So looking at the application of the human rights monitoring mechanisms within each treaty, let's start from the CEDAW. I mean the CERD. The CERD is the Convention on Elimination of All Forms of Racial Discrimination. So it was the first treaty body established, and it has reviewed applications on violation of the International Convention of Elimination on All Forms of Racial Discrimination. It was adopted in 1969, so it's, as I said, the first treaty body to be established. This treaty body have 18 members. These 18 members will look into state reports that are presented on the convention, on the CERD convention. They will also look into individual complaints. They will make country visits and inquiries. They will also receive, in some cases, interstate complaints, even though, as we said, they are rarely used. So these 18 members of the Committee on the Elimination of Racial Discrimination are the first ones, because this is the first committee established, as we said, and it was established in 1969. So the convention itself, the CERD convention, have 156 state parties. This is a huge number of states, 156 state parties. And these state parties will will send their state reports to the CERD and how they have been doing on the specific human rights provisions within the CERD. So this was the first United Nations human rights instrument outside the provisions of the human rights in the UN Charter, and it's the first to establish an international monitoring system, including a procedure for individual complaints. So CERD have many firsts. It's the first treaty body. Also, it's the first treaty body to accept individual complaints. So the conclusion of the convention was a priority objective, and it was not the list of the new member states of the UN, which had, just gained their independence in the early 1960s, mostly African states, and the convention contains 25 articles, and 7 of the 25 articles are normative in character, and it provides for a broad definition of racial discrimination. You may see this under Article 1 of the CERD, and the Convention also sets out a number of detailed prohibitions on and obligations to prevent discrimination on the grounds of race, color, descent, or national or ethnic origin. So states are under obligation to criminalize dissemination and propagation of ideas which are based on racial superiority and hatred, and participation in racial organizations or activities. So the committee is established under the treaty, under the CERD treaty, and it reminded states that its undertaking was not only an obligation to enact certain criminal laws which criminalize racial injustice, but also to ensure that the laws are effectively enforced. And the international monitoring procedures are dealt with in the second part of the convention. The first part of the convention, as we said, is more or less normative. The first 7 articles out of the 25 articles of the CERD are normative. The treaty body procedure, or the international monitoring procedure, is found after Article 8, Article 8 to 16 of the CERD. The second part of the convention deals with how the treaty body will entertain cases. It's more or less dealing with the institutional framework. So, as we said earlier, the committee, the treaty body, have 18 independent experts. These experts are independent from their home states. They are human rights experts, and their allegiance is only to human rights, not to their governments, and the state parties will nominate them. Also, the state parties will have an obligation to report to the committee, and the report will be submitted initially 1 year after the convention enters into force, and then periodically the report will be submitted every 2 years. So ኢኒሻል ሪፖርት ለሰርድ የሚያስገባው አንድ ሀገር ሰርድን በፈረመ በአንድ ዓመት ውስጥ ኢኒሻል ሪፖርት መግባት አለበት። ከዛ ደግሞ ፔሪዮዲክሊ ደግሞ በየ2 ዓመቱ ሪፖርት ማስገባት አለባቸው ሀገራት ማለት ነው። ሌላው ደግሞ the committee will also deal with individual complaints. It will also have a power to look into inquiries and make state visits if states have consented to this procedure ማለት ነው። So the second treaty we will be seeing is the ICCPR. The ICCPR, the Convention on Civil and Political Rights, have a treaty body called the Human Rights Committee. The Human Rights Committee was created in 1976, and it will review individual complaints, state reports made on the basis of the International Covenant on civil and political rights. The Human Rights Committee, the treaty body of ICCPR ማለት ነው, also have 18 members, like the treaty body on CERD ማለት ነው. And seeing the data of the state parties to the ICCPR, 146 states are parties to the ICCPR. 146 is a big number. 146 ሀገራት የICCPR ፈራሚዎች ናቸው. So these countries will report to this treaty body, which is the Human Rights Committee. The ICCPR contains 53 articles. 27 of these are normative articles. They lay down the legal rights, the civil and political rights. It also consists 2 optional protocols, which are adopted consequent to the main treaty ማለት ነው. So when we see Article 28 of the ICCPR, it establishes a Human Rights Committee. It also tells us that there are 18 members, like we said, and the treaty body, the Human Rights Committee, will have a mandate to consider the reports that all state parties will submit regularly to the committee. It will also consider interstate complaints. It will deal with individual complaints that might come before it under the optional protocols ማለት ነው. So states need to ratify the optional protocol, as we said, so that individuals could bring individual complaints ማለት ነው. Okay. So who's speaking? You have questions, Ezra? Okay, I need to mute Ezra. Ezra, are you with us? Okay, can you please mute yourself? I'm already muting you, okay. Okay, so as we said, the Human Rights Committee, the treaty body of ICCPR, will look into individual complaints and oh, yes, Ezra. You have a question? If you have a question, you can unmute yourself. So besides seeing state reports, individual complaints, and interstate complaints, the Human Rights Committee will also adopt general comments on various human rights issues presented to it. The ICCPR have 2 additional protocols. The first additional protocol deals with the competence of the committee to receive individual complaints. This protocol expands the procedural aspect of the ICCPR, so states need to opt into this protocol, into this additional protocol, so that their citizens can bring individual complaints to the Human Rights Committee. ስለዚህ ኢትዮጵያ ለምሳሌ የICCPR ፈራሚ ናት፣ ነገር ግን አዲሽናል ፕሮቶኮሉን ካልፈረመች ኢትዮጵያውያን ወደ Human Rights Committee individual complaint ማቅረብ አይችሉም ማለት ነው። ስለዚህ not only the ratification of the ICCPR but also the ratification of its additional protocol is important for individuals to file a complaint before a treaty body. So first additional protocol, as I said, is a protocol which deals with the competence of the Human Rights Committee to receive individual complaints, and And the second additional protocol deals with the abolition of death penalty. So ባለፈው እንዳየነው additional protocols ከዋናው ማደር ኮንቬንሽን በኋላ የሚወጡ ኢላቦሬቲንግ የሆኑ ፕሮቶኮሎች ናቸው። like in the same way we have regulations after proclamations ማለት ነው። yeah so there is not there is no an express mandate of adopting general comments to the committee both in the ICCPR and additional protocols. However, the committee will still adopt general comments ቅድም እንዳልነው ስቴት ሪፖርቶችን ብቻ ሳይሆን የሚያዩት ወይም ኢንተርስቴት ኮምፕሌንቶችን ብቻ ሳይሆን የሚያዩት ኮሚቴዎቹ they will also adopt general comments. There is no as such an express mandate to adopt general comments, but in their day-to-day activities, because they will face various human rights issues and situations, they will adopt general comments, and those general comments will help states to improve their human rights situation, because the general comments are usually focused on a certain human rights theme. The Human Rights Committee has the mandate to consider report from states on the basis of Article 40 of the ICCPR. Even if Article 40 of the Covenant gives power to the committee to consider state reports, it does not clearly specify the periodicity of the reports. In other words, the Covenant does not specify within how many years that a state party to Covenant needs to submit its report. However, as the practice of the Human Rights Committee shows, the committee sometimes requires only 3 years, but the normal period of submission of reports is 4 years. So states need to submit their reports every 4 years, but it may also extend the period of submission to 5 years. Why would the committee make such distinction? ለሚለው ጥያቄ it depends on the situation existing in the countries. ለምሳሌ if a certain state gives rise to a serious concern of human rights violation, the committee requires that state to submit its report within 3 years. But in normal cases, it requires states to submit their reports within 4 years ማለት ነው። So if a state give a minor concern of human rights violation, the committee will allow those states more period to submit their reports. The logic behind this is that there would be no problem if countries which relatively enjoy better human rights realization are given more period. In addition to this, the committee may sometimes require special reports which are called supplementary reports. These special supplementary reports are type of reports that the committee requests a given state party to submit its report before the required period. For instance, though a certain state have 4 years to submit its periodic report, the committee may request the state to submit another report before that period. So this special report was introduced by the committee in 1991. In 1991, Rwanda was requested to submit special report. The committee also requested special report from USA in 2005. So what would be the response of the committee if the state parties fail to submit their reports? የምንለውን ስናይ the committee adopted a procedure called examination of situation. This procedure named examination of situation was adopted in 2001, and it's a method of the Human Rights Committee to cope with states who do not comply with their treaty obligations. So in these circumstances, the committee will schedule examination of situation of a certain country, of the human rights situation obviously, even in the in the absence of a report from that state. ስለዚህ ስቴቷ ሪፖርት ባላቀረበችበትም ሁኔታ if there is an extenuating circumstances and massive violation of human rights, the committee will examine the situation in the country. So basically, this will happen only after state parties have failed to submit their reports, but the committee will make schedules of examination of situation without receiving any report from the state. ማለት ነው ስለዚህ ያለ ሪፖርትም ኤግዛማይን የሚደረግበት ሁኔታ አለ በጣም የከፋ የሂውማን ራይትስ ሲቹዌሽን የሚያጋጥም ከሆነ ማለት ነው ያ ሶ ሂውማን ራይትስ ኮሚቴን የሚመለከተው ኢሹዎች እነዚህ ናቸው ሂውማን ራይትስ ኮሚቴ የአይሲሲፒአር ትሪቲ ቦዲ ነው ስለዚህ በውስጡ እንዳሉት መብቶች all human rights are equal civil and political rights ላይ ደግሞ ከመንግስት ነው በጣም respect የሚጠበቀው so if the government is no longer respecting even though report ባይቀርብም human rights committee ከ2001 በኋላ ባለው በተሰጠው mandate without reportም የአንድን ሀገር human rights situation investigate ያደርጋል ማለት ነው so the third treaty is the committee on the elimination of discrimination against women. This committee is a treaty body of the CEDAW. It has reviewed applications on the Convention on the Elimination of All Forms of Discrimination against Women since 1981. ከ81 ጀምሮ ሪቪው ሲያደርግ ነው የቆየው women's rights በተመለከተ ያሉ ነገሮችን ሪቪው ሲያደርግ ነው የቆየው it has 23 members more than the ICCPR and the third 23 members are within the committee on the elimination of discrimination against women and it sees all issues concerning the CEDAW So equal rights of women and men, as you all know, is a basic principle of law embodied in the UN Charter and other numerous human rights instruments. The UN Charter in its preamble, in its specific articles, we can see Article 1, we can see Article 55 of the UN Charter provides for women's rights. And also this principle of equality is proclaimed in the UDHR. Article 1 and Article 2 of the UDHR provides for women's rights and in addition to this, state parties are also required to specifically undertake obligation to ensure men and women enjoy equal rights. Article 3 of the Twin Covenants also states this. On women's rights, there have been various efforts internationally, even before the adoption of the CEDAW. We can see the Commission on the Status of Women, which have adopted various legislations on the rights of women. We can see the ILO, the International Labour Organization, which also provides for an equal pay for women, equal remuneration and protection from hazardous work environment and which allows for maternity protection. So finally, in 1967, the UN General Assembly adopted the CEDAW. The CEDAW, as you know, is the Convention on Elimination of Discrimination Against Women, and it was adopted as a reaction to the growing concern that additional means for promoting and protecting women's human rights is necessary. So in 1972, the Secretary General, the UN Secretary General, asked the Commission on the Status of Women to request the view of member states as to the form and content of a possible binding instrument on the subject. And it was through this whole process that the CEDAW was adopted in order to give a binding treaty for the rights of women. So the convention consists of 30 articles. CEDAW has 30 articles. The first 16 are normative articles, which flesh out the substantive rights. The definition of discrimination against women is provided in the first article. The definition for discrimination against women is provided in the first article of the CEDAW, and it's more detailed than many other international instruments because this is a specialist, because it's a specialist international instrument. It is more detailed and it provides for discrimination against women definition more broadly than any other international instruments. So in both its definition and in other provisions of the convention, the exclusion and restriction against women is dealt with. So the convention gives various rights, and it recognizes the rights of women. It identifies many areas where there have been notorious discrimination against women. For instance, you can take political and civil rights. It also encompasses economic rights. It's an instrument which basically you can see the indivisibility of human rights. So it provides both for political and civil rights of women and also economic and social rights of women. Yeah, so the treaty body have 23 members, and they will see state reports. States will report back to the CEDAW, treaty body, the Committee on Elimination of Discrimination Against Women. It will see state reports. It will also look into individual complaints from women who are victims of gender-based violence or any other right which is stipulated in the convention. So the fourth convention is the International Convention on Economic, Social, and Cultural Rights. This convention was adopted with the ICCPR, but it does not have a treaty body until recently. The treaty body of the ICSCR was first established in 2008. So it's only after 2008 that International Covenant on Economic and Social and Cultural Rights have a treaty body. Maybe you can ask why is the reason that ICSCR does not have a treaty body. Is it because the international community was giving much weight to the ICCPR than ICSCR? That's something to be argued of, but the fact is that it have a treaty body only in 2008. So this treaty body will look into the violations of economic, social, and cultural nature. Individuals can file a complaint if their states have ratified this treaty, and if they are also giving competence to the optional protocol, which grants a right to entertain individual complaints. So 142 states are parties to the covenant on economic, social, and cultural rights. The report from the states will be examined by the treaty body. Yeah, even though it's not something, as we said, that normally happens, interstate complaints may also be entertained, and individual complaints may also be accepted on economic, social, and cultural rights. It may be on the right of housing. If a person is evicted by a state who have ratified this treaty, the treaty, it can bring an individual complaint to the treaty body alleging the violation to the right of housing. So the treaty body will give remedies. It may request the state to compensate that individual or to reinstate him back to where he was living, to his own housing, or it may request for a change in laws, legislations, and practices against the convention. So we have in the fifth place the Committee Against Torture. The Committee Against Torture is established on the basis of CAT, the Convention Against Torture, and other cruel, inhuman, or degrading treatment. It has 10 members, and these 10 members, as we have seen in all the other treaty bodies, will look into state party reports on torture. Also, it will entertain individual complaints from victims who have been unlawfully detained and tortured by state parties. Yeah, so in the interest of time, we can fastly go to the Committee on the Rights of the Child, which is the treaty body established by the Convention on the Rights of the Child. This committee will also see issues arising from the Mother Convention. It will look into state reports and individual complaints where child rights are affected. So there are optional protocols to the convention. There is an optional protocol on the involvement of children in armed conflict. It sees issues where states have given competence to its optional protocols. It have 18 members. These members would also look into the country's human rights situation using inquiries and state visits if the countries have authorized so. The Convention on the Rights of Child have 190 state parties. It has the highest state parties in the world. 190 states is a very big number, as you can perceive. It have 54 articles, and 42 of the 54 articles are normative articles. They flesh out the rights of the child, and the remaining articles will envisage the institutional framework on the rights of a child. And then we have the Committee on Migrant Workers, and as you rightly guessed, the Committee on Migrant Workers is a treaty body which emanates from the International Convention on the Protection of the Rights of Migrant Workers and members of their families. It have 14 members. This committee have 14 members, and it has its first session in March 2004, and it reviews applications, state reports, and individual complaints on the Migrant Workers Convention. And then we have the Committee on the Rights of Persons with Disabilities. This is the ninth major international human rights convention. It is a treaty body established in 2008. So it has its first session in 2009. This is a very recent one, and it has 18 members. ሶ የዲስአቢሊቲ ራይትስ ኮንቬንሽን ትሪቲ ቦዲ ኮሚቴ ኦን ደ ራይትስ ኦፍ ፐርሰንስ ዊዝ ዲስአቢሊቲስ ነው የሚባለው 18 ሜምበሮች ያሉት ማለት ነው። and finally we have the committee on enforced disappearance. ኢንፎርስድ ዲስአፒረንስ ትሪቲውም ራሱ የቅርብ ጊዜ ነው እንደምታውቁት። የትሪቲ ቦዲውም ደግሞ ኮሚቴ የቅርብ ጊዜ ነው፣ በ2011 ነው የተቋቋመው ማለት ነው ኮሚቴው የትሪቲ ቦዲው። So 10 ሜምበሮች አሉት። it has 10 members and it will enforce and it will monitor the implementation of the International Convention for the Protection of all persons from forced disappearance ማለት ነው። ስለዚህ እኚህ ናቸው ትሪቲ ቦዲዎቹ፣ 9 ትሪቲ ቦዲዎች እነዚህ ናቸው። most of them are called committees ኮሚቴ ነው የሚባሉት አብዛኞቹ። yeah, I hope this is clear and በደንብ ደግሞ በጥልቀት when you read things it will be more clear ማለት ነው። So we will wrap up today's discussion before going to the movie review presentations. Let's wrap up our discussion on treaty-based mechanisms. So how effective are these mechanisms? Are they really helping out the protection of human rights የሚለውን እዚህ ላይ ሪፍሌክት እናደርግና we will finish our discussion on treaty-based mechanisms. We have seen 4 sub-mechanisms to protect human rights within the treaty-based mechanism. After wrapping up this discussion, starting next class on, we will see the charter-based mechanism. ባለፈው ጊዜ እንዳልነው universal human right protection mechanisms treaty-based እና charter-based በመባል ለሁለት ይከፈላሉ። ሶ ትሪቲ ቤዝዱን እና በዛ ውስጥ ያሉትን ደግሞ 4 ሜካኒዝሞች አይተናል ማለት ነው። ሶ ዛሬ ዲስከሽኑን ራፕ አፕ አድርገን ኔክስት ክላስ ላይ we will start looking into the second universal human rights protection mechanism which is the charter based mechanism ማለት ነው። ሶ how do you see the effectiveness of the treaty-based mechanism? Do you think it's effective? Would it help the actual protection of human rights? What are its setbacks? What are the things that need to be improved? What are the ramifications? የሚለውን ነው የምናየው ማለት ነው አሁን ባሉን ቀጣይ 5 እስከ 10 ባሉ ደቂቃዎች and then to finish the class on time, we will go into the movie review presentations. So how do you see the treaty-based mechanism? Do you see it effective? What problems or potential problems do you see in this mechanism? Any reflections from the class? Yes, Rama, please. Ruhama, your voice is somehow lowered. Yeah, that's true. That's true. Even the state reports are just, as you said, submitted by the government themselves. But again, we said that there are shadow reports from non-governmental organizations and the UN agencies. So maybe that somehow tries to balance the credibility of the state reports. But then again, all the other mechanisms, as Ruhama said, are consensual. So that still poses a problem. So what other defects do you see? Anybody from the class? How do you see the effectiveness of the treaty-based mechanisms? State reports, interstate compliance, individual complaint mechanisms, inquiries, country visits. These are the treaty-based mechanisms. So what problems do you see? Anyone else from the class? You can unmute your mics and reflect. Okay, so firstly, a large number of countries have not recognized the competence of the relevant treaty-based mechanisms. So that's a problem. A state needs to recognize the treaty-based mechanism so that it will be bound by it. So most of them have not recognized the competence of the treaty-based mechanisms, or they have failed to ratify the treaties in the first place. So this is the first problem. And secondly, a number of treaty-based mechanisms, such as, for instance, the individual complaint mechanisms, suffer from their own success. Sometimes the overwhelming number of individual complaints would lead to a serious delay in decision-making processes. So the individual complaint mechanism is relatively successful from the other remaining three mechanisms, because there are many complaints filed to the treaty bodies. But this success has a ramification on the flip side, because the number of individual complaints is overwhelming, so much so that the treaty bodies would have problems in making swift decisions and decisions without a serious delay. So justice delayed is justice denied, and the treaty bodies have problems in delivering decisions timely because they have a backlog of cases. And for those treaty bodies that consider individual communications, petitions are very, very much increasing. And this, as I said, have led to significant delays. For instance, if you take the Human Rights Committee, it has 333 pending cases which have not been yet decided. And the average time lag between filing a case and receiving final decision is around 3.5 years. So in average, a person who filed an individual complaint before the treaty body of the ICCPR, which is the Human Rights Committee, will need to wait for 3.5 years to receive a final decision. And this is such a long time. So this is one of the problematic areas of the treaty-based system, even though it's in a way successful, because people are believing that their rights could be respected and they can be reinstated to a better position if they file a complaint, yet still it would take them longer to get decisions. So this would obviously have a negative impact on the petitioners who would face a long wait before their case is decided upon, and state parties are often faced with a committee's request for implementation of an interim measures over a long period of time. So it should be noted that some of the states do not cooperate with the committee despite frequent reminders to submit their comments on the individual communications, and this also further delays the consideration of the complaint because the states don't respond timely. Even if the treaty body have done its best, the state might default in responding timely to comments. And also many of the individual complaint procedures are suffering from understaffing, underfinancing. Even most of them don't have full-time staff, so this is also one of the problems. Mostly this is what we can say about the setbacks of individual complaint mechanism. When we come to the problems of state reporting mechanism, most states don't present initial and subsequent reports timely to the treaty bodies. Some of the states do not comply with reporting obligations, maybe for political reasons or for lack of resources. But the fact is most states do not submit reports, or even if they submit, it's not a timely submission. The High Commissioner for Human Rights will assist states so that they would have a capacity to draft their reports, but still some states don't present their reports. Or they will submit it late. And the problem with the treaty bodies is they are not binding. I mean, the treaties are binding, but the treaty bodies' decisions or judgments, they are quasi-judicial, so their judgments or their views or their recommendations, as the case may be, are not legally binding. So this is a very problematic area. The implementation of the judgments and recommendations of the treaty bodies will fall upon the will and whim of the state parties. So it's up to state parties to execute the decisions of the treaty bodies. They are not binding, and this is a very critical problem. So these are some of the things that really plague the treaty-based mechanism. When we summarize the limitations, we can say that it's consent-based. The fact that it's consent-based is the first problem. And second, there is no supervisory body which is permanent. The supervisory bodies or the treaty bodies are working on voluntary basis. They are ad hoc committees. They're working voluntarily and their decisions are not binding. So this is also a second problem. And another third problem is overlapping of obligations. Like, for example, if a state is signatory of all the 9 major treaties, it's going to need to report to all those 9. And the average time to report will overlap. So this will create burdensome obligation for states to comply with. This will make it difficult even more for developing countries with less resources. So they will be reporting to various treaty bodies every now and then, and it will become burdensome for them. ለምሳሌ አንድ ሀገር የዘጠኙም ትሪቲዎች ፈራሚ ነው ብንል ቢያንስ በየ6 ወሩ ትሪቲ ሊጽፍ ነው ሪፖርት ሊጽፍ ነው ለትሪቲ ቦዲው ማለት ነው ስለዚህ this may be overwhelming for the countries ማለት ነው especially for developing countries. So these are some of the problems. There have been attempts to overcome these problems, especially from 2006 onwards, there is this thing called Harmonized Guideline on Reporting to the Treaty Bodies. So this, in a way, helps states to compile an overall and general report, and that report will be forwarded to all treaty bodies. It will only need to provide somehow minor adjustments to make specific reports to the specialized treaty bodies. This has in a way helped, but yet it's not widely used, and the problem still persists. ስለዚህ የትሪቲ ቤዝድ ሜካኒዝሞች ፕሮብለም የመጀመሪያው ኦቨርላፒንግ ሪኳየርመንቶች መኖራቸው ነው። ሁለተኛው ደግሞ ኮንሰንት ቤዝድ መሆናቸው ነው። ሶስተኛው ደግሞ ባይንዲንግ ዲሲሽን አይሰጡም ትሪቲ ቦዲዎቹ። ሶ ኢት ኦል ፎልስ አፖን የስቴት ፓርቲዎች ፖለቲካል ዊሊንግነስ እና የነን ገቨርንመንታል ኤንጂኦዎች እና ሂውመን ራይትስ ኢንስቲትዩሽኖች ሎቢ ማድረግ እና ለማድረግ ላይ ይወሰናል ማለት ነው ዲሲሽኑ መተግበር አለመተግበሩ። So these are some of the defects, but with all its defects it's widely used and it's a good mechanism. And the treaties themselves and the general comments made by the treaty bodies will help and guide states to adopt national policies, national laws. They are the basis to make the national human rights regime work better, and it helps protect human rights more effectively and substantively, even though it have these defects ማለት ነው። Yeah, so these are some of the things. Kia, I'm just seeing your question now. I think you write it before I repeat, or okay. So if you've not already heard me, the problems with the treaty-based mechanism is that first, it's not legally binding. Unlike domestic courts or regional human rights mechanisms, as we shall see in our next classes, the treaty bodies' decisions, recommendations, judgments, whatever you call them, are not binding. This is the first problem. And the second problem is that they are consent-based. So for you as an individual to file a complaint before the treaty body, your country of citizenship needs to consent to that specific procedure. So they are consent-based, and this is also another problem. And a third problem is an overlap in obligations. So states will be burdened with various obligations from various treaties, and some of them, their deadlines will be overlapping, and this makes it difficult for states to report. All right, Kia. If there are no other questions, we can directly go to the presentations, to the movie review presentations. Try to make it short and to the point, and tell us which human rights instruments are violated. Yes, Fikri? Yes. All right, please proceed. Yeah. Yeah, so treaties are something consent-based. በኮንሰንት ላይ ተመስርተው ነው ትሪቲዎች አፕሊካብል የሚሆኑት። ሂውመን ራይትስ ግን ዩኒቨርሳል ናቸው። ትሪቲ ስላልፈረምኩኝ ብሎ አንድ ሀገር ለምሳሌ የአይሲሲፒአር ፈራሚ ያልሆነ ሀገር እኔ አይሲሲፒአር አልፈረምኩኝም እና ሲቪል እና ፖለቲካል ራይቶችን አላከብርም ሊል አይችልም። ምክንያቱም they are universal እና ሊወሰዱና ሊነጣጠሉ የማይችሉ መብቶች ስለሆኑ ሰብአዊ መብቶች ትሪቲውንም ፈረመም አልፈረመም ሲቪል እና ፖለቲካል ራይቶችን የማክበር ግዴታ አለበት። ነገር ግን ትሪቲውን ግን ከፈረመ አንድ ሀገር በዛ ትሪቲ መሰረት ስቴት ሪፖርት ማቅረብ ይኖርበታል። እንደገና በዛ ትሪቲ መሰረት ደግሞ የዛ ሀገር ዜጎች ለአይሲሲፒአር ትሪቲ ቦዲ ኢንዲቪዥዋል ኮምፕሌንት ማቅረብ ይችላሉ። አይሲሲፒአር ፈርመሃል፣ ነገር ግን እንትኔ መብቴ እየተከበረ አይደለም፣ ሲቪል እና ፖለቲካል ራይቴ በተፈረመው መሰረት እየተከበረ አይደለም ብሎ ሂውመን ራይት ቦዲው ላይ አቤቱታ ለማቅረብ ይቻላል ማለት ነው። ስለዚህ even though the country is not a party to the ICCPR, it needs to respect civil and political rights. But if it's a party to the treaty, the citizens in that country will have the right to lodge a complaint within the Human Rights Committee ማለት ነው። And again, the state also would be held accountable whether it's actually implementing civil and political rights ማለት ነው። ስቴት ሪፖርቲንግን በመጠቀም ለትሪቲ ቦዲው ለአይሲሲፒአር ትሪቲ ቦዲው ሪፖርት ታደርጋለች ማለት ነው ሀገሪቷ። ስለዚህ ምን ያህል በተግባር ላይ ውሏል አልዋለም የራይቱ ኢምፕሊሜንቴሽን የሚለውን ትራክ ለማድረግ እና ሀገራትን አካውንተብል ለማድረግ ነው እንጂ የሚጠቅመን የትሪቲዎቹ መፈረም ስላልተፈረሙ ራይቱ አይከበርም ወይም ዩኒቨርሳሊቲው ኮምፕሮማይዝ ተደርጓል ማለት አይደለም። Any other questions? So we just finalized our discussion on the treaty-based mechanism. So please ask questions if something is not clear on the treaty-based mechanism. ስለዚህ አራት አይነት እንትኖችን አይተናል። ፕሮቴክሽን ሜካኒዝሞች እንደገና ደግሞ በዘጠኙ ትሪቲዎች ውስጥ ደግሞ እነኚህ ፕሮቴክሽን ሜካኒዝሞች እንዴት ወርክአውት እንደሚያደርጉ briefly ለማየት ሞክረናል ማለት ነው። So if something is not clear, please ask. Otherwise, we will finalize today's discussion and we will proceed to the movie review presentations. Okay, Fikri, please proceed. That will help us track the actual implementation of human rights because the state will report back to the treaty bodies. Also, other states will have the opportunity to file an interstate complaint on that state because already ፈራሚ ስለሆነች ለኢንተርናሽናል ኮሚኒቲውም አካውንታብል የመሆን መንገድ ይከፍታል ማለት ነው ከተፈረመ ትሪቲው። and again እዛ ውስጥ ያሉ ኢንዲቪዥዋሎች ደግሞ መብታቸውን ኢንተርናሽናሊ እንዲጠይቁ if the domestic legal remedies are unduly prolonged, if they are not available internationally, human rights litigate የማድረግ መንገድ ይከፍታል ማለት ነው። እንደገና ደግሞ the treaty bodies ደግሞ international bodies will come into that country and will inquire the human rights situation if there is a report of human rights violation ማለት ነው። So it will open the door for an international accountability. So መፈረሙ የኢንተርናሽናል ትሪቲዎች መፈረም ጥቅሙ ይሄ ነው። It will give individuals a broad recognition of the rights. The rights are already there. They are eternally everlasting rights. They were there before the treaties and they will be there after the treaties. ነገር ግን the treaty will solidify and reinforce the application of the rights. All right. Okay, Ruhama, please proceed. Yeah, so treaty body ላይ የሚሰሩት ሰዎች the people working on the treaty bodies are working voluntarily. So they are not permanent and full-time employees of that treaty body. They work I'm sorry, I'm having a flu. So they're not working there permanently. They're not working full time. They're nominated by state parties. They work there, but it's not something they work, day in, day out. They will meet within a specified period of time depending on the treaty. They're working permanently and on a full-time basis. ስለዚህ ያን ማለት ነው አድሆክ ናቸው ፐርማነንት አይደሉም ስል በየጊዜው በስቴት ፓርቲዎች እየተመረጡ ስቴታቸውን ሪፕሬዘንት አድርገው ሳይሆን ፐርሰናሊ እንደ ሂውመን ራይት ኤክስፐርት ሙያቸውን ሪፕሬዘንት አድርገው የሚገቡ ሰዎች ናቸው ሶ በየጊዜው ይለዋወጣሉ ማለት ነው ስለዚህ it's not something a permanent institution the treaty body is not a permanent institution I mean per se the treaty body is a permanent institution but the individuals there are not people hired on a full-time basis እና ስለዚህ ለዛ ነው in a way ad hoc ናቸው ያልኩት ማለት ነው all right great any other questions if something is not clear it's it's good if you ask this is an online class and I want everyone to be clear with everything that we are discussing So if there is a thing that you have missed, you can also ask that. I can repeat things. Okay, if there are no questions, we can proceed to the movie review presentations. We have 30 minutes remaining, so we can proceed to those. So you're going to tell us briefly which human rights are, involved in the movies. Maybe you can tell us which provisions of the major international human rights instruments were violated, or you can tell us the relevance of the movie to various human rights issues. So try to make it brief and to the point. And we can start the presentations. Anyone who would like to voluntarily start? Okay, Jami, you were assigned to Beast of Nations. Thank you, Jamie. That was an excellent review. Uh, anyone who wants to continue with the movie review? The second movie is Blood Diamond. Yeah, Blood Diamond. It's Yadda who was assigned to review that movie. Oh. Yadda, we have difficulties to hear you. Yes, but it's good if you can raise your voice a little bit. Yadar, we're missing you intermittently. We're missing you in between. You said there was a degrading treatment, and then now you're continuing to. We're missing you, like it's not clear. Yes, but it's not very clear. Maybe if the place you are does not have a good network connection, maybe you can write us in the chat box. Maybe writing for us which of the rights were violated. Yeah. It was very clear earlier in our session when you were asking questions, but now we cannot hear you very well. Okay, it's better. Just let's try to hear you. So you're telling us something about education, if I'm not mistaken. It's okay. It's okay. It's okay. Okay, thank you too. Next, we have the movie Desert Flower. Heyran was assigned to review that movie. Is Heyran here? Yes, she's here. I'm very sorry. I lost my internet connection. That's why I'm very sorry. So Hiran was about to present for us on the movie Desert Flower. Yes, yes. Okay, thanks, Heran. Noura, okay, you have reviewed the report. Yes, please continue. Yes, please. Yes, please. Yes, yes. Yes, ቅዱስ you can. Yes, is that Saron? Yes, Saron, yes. Zero Dark 30 is the movie which you're assigned, right? So I hope this movie review exercises were a good learning opportunity for you all, even though you're not assigned to review for us a specific movie. I hope most of you might have seen the movies. So this closes our today's class. We will meet on Thursday, and I will be talking with Rihanna on some makeup classes if need be. So have a good Monday afternoon, and goodbye.